In this lecture, let us discuss emergency provisions of the Constitution. We shall be discussing national emergency under Article 352 of the Constitution, President's Rule under Article 356, and financial emergency under Article 360 of the Constitution. But first things first, what are these emergency provisions doing in our Constitution? And what is the logic, what is the rationale behind having these emergency provisions in our Constitution? If you recall our first lecture, where we discussed the distinction between a unitary and a federal Constitution, I told you that there are 5 important characteristics which define a particular federal Constitution. That means if we have to judge whether a Constitution is federal or not, we compare it to the Constitution of the United States. And if there are these 5 characteristics which are present in this Constitution, we say this Constitution is federal, otherwise it is something else. But which are these 5 important characteristics which define a federal Constitution? Number 1, dual government. Number 2, distribution of powers. Number 3, written Constitution. Number 4, supremacy of the Constitution, the rigidity of the Constitution. And number 5, independent judiciary. When we look at these emergency provisions, they change and transform our federal Constitution into a unitary one, even without amendment to the Constitution. That means even without resorting to a constitutional amendment under Article 368 of the Constitution, these emergency provisions, they change our Constitution, transform our Constitution, and turn it into a unitary Constitution. Which means 2 important characteristics of a federal Constitution get affected because of these emergency provisions. 1, dual government. 2, distribution of powers. And I'll tell you later how. Right now, keep in mind that these emergency provisions, what they do, they tell us that our Constitution is amphibian in character. In normal circumstances, our Constitution behaves as if it is a purely federal Constitution. But in abnormal circumstances, our Constitution changes its form and character and turns itself into a unitary Constitution. Because 2 important characteristics are affected: dual government and the distribution of powers. Dr. B.R. Ambedkar, the architect of our Constitution, he said, American Constitution is into a tight mold of federalism. It can never change itself, it can never change its form, it can never change its character, it can never turn unitary. Similarly, Australian Constitution, that means US Constitution, Australian Constitution, they are federal. Under no circumstance can these federal Constitution turn itself into a unitary Constitution. But our Constitution, it can behave in normal circumstances as if it is a purely federal Constitution. But in abnormal circumstances, it behaves as if it is a unitary Constitution. But what is the logic? Why do we have these emergency provisions in the Constitution? And the reason is to uphold the unity, integrity, and sovereignty of the nation, to safeguard the territorial integrity of the nation, to safeguard the Constitution of India, to safeguard the democratic political system in India. We have these emergency provisions. Long story short, our Constitution is federal in character. But what if there is a war? What if there is external aggression? What if there is armed rebellion? What if there is breakdown of constitutional machinery in a state? Our Constitution gives a provision. Our Constitution gives an option that our Constitution can change and turn itself into a unitary Constitution where central government enjoys all the control, all the powers. That means distribution of powers. Dual government gets affected because of these emergency provisions. Center becomes very powerful, all encompassing, and when center becomes all powerful, our Constitution turns itself into a unitary Constitution. But that is only if there is a grave threat to the unity, integrity of the nation. When the democratic political system is under threat, when the Constitution is under threat, then our Constitution behaves as if it is a unitary Constitution, even without amending the Constitution, even without taking recourse to Article 368 of the Constitution. Which means, when we look at this chapter, first we need to understand what do these emergency provisions do to our Constitution. And the answer is, these emergency provisions, even without amending the Constitution, they change the shape, character, form of our Constitution, and our federal Constitution turns itself into a unitary Constitution. But that is only to uphold the territorial integrity, sovereignty of the nation, to ensure that democratic political system is safeguarded, to ensure that the Constitution is safeguarded. And how? To make you understand, we need to now jump to national emergency, then to President's Rule, and then to financial emergency. And everything related to this chapter would become crystal clear to you. First, let's look at national emergency under Article 352 of the Constitution. What is national emergency? Constitution says when the President is satisfied. But how do you satisfy the President? That there is a grave danger, there is a grave threat to the security of the nation, or there is a grave threat to the security of a particular state, or there is a grave threat to the security of a part of that state. That means there is a threat. There is a threat to the security of the entire nation, or any state, or any part of that state. If the President is satisfied that there is this threat, but this threat is coming from either because of war, or because of external aggression, or because of armed rebellion, then what President can do? President can proclaim national emergency under Article 352 of the Constitution. That means if the President is satisfied that there is a danger to the security of the nation, there is a danger to the security of a state, there is a danger to the security of a part of that state, and this danger is because of war, external aggression, or armed rebellion, what the President can do? President can proclaim national emergency. But the point is, what is the difference between war, external aggression, and armed rebellion? Please understand, when the emergency is imposed on the grounds of war or external aggression, we call it external emergency. And when the emergency under Article 352 is imposed on the grounds of armed rebellion, we call it internal emergency. But what is the difference between war, external aggression, and armed rebellion? War is always declared. Pakistan declares war on India. India declares war on Pakistan. India declares war on China. China declares war on India. Since war has been declared, because of which the security of the nation or any part of the state is under threat, what the President can do? He can proclaim national emergency. But sometimes the threat is not only because of an external enemy. Because war, external aggression is from outside. Sometimes the threat to the security of the nation can come from within as well. For example, there are Maoists in India, Naxalites in India, terrorists or separatists in Jammu and Kashmir. And they create a situation where there is a grave danger, grave threat to the security of the nation, security of the state, or any part of that state, then under armed rebellion, national emergency can be proclaimed by the President. That means one ground by which we can know that the security of the nation or the security of the state is under threat is because of war. And war is always declared by a nation. China declares war on India, India declares war on Pakistan. That's war. Sometimes it's also external aggression. That means, for example, China is pushing troops along the line of actual control. China is saying we have not waged any war, but their troops have infiltrated across the line of actual control. Pakistani troops or terrorists, they have infiltrated along the line of control. In that case, since they have not declared war, but they have committed aggression on India. And it is this external aggression which is posing imminent danger, threat to the security of the nation. On external aggression ground, national emergency can be proclaimed by the president. But war external aggression. This is because there is an external danger, external threat. But sometimes the threat is from within the nation. And in that situation, president can proclaim national emergency on the grounds of armed rebellion. And when president proclaims national emergency on the ground of war or external aggression, we call it external emergency. And when the president proclaims national emergency on the grounds of armed rebellion, we call it internal emergency. To recap, if the president is satisfied that there is a danger, there is a threat to the security of the nation, to the security of a state, to the security of a part of the state, and this threat is because of war or external aggression or armed rebellion, what the president can do, he can proclaim national emergency, right? But we have also discussed the office of the president, and then I told you that one phrase that we can use for the president is that president is a rubber stamp. So president, when we say if the president is satisfied, he can proclaim national emergency, that is not the personal satisfaction of the president. That is the satisfaction of the cabinet, headed by the prime minister. That means if the president is satisfied that there is a grave danger to the security of the nation because of war or external aggression or armed rebellion, president can proclaim national emergency. But president cannot proclaim national emergency on his own. President has to proclaim national emergency only on the advice, that too of the written advice of the cabinet. Cabinet meeting takes place, cabinet takes a decision, written advice is communicated to the president. Based on this written advice, president proclaims national emergency. That's point number one. Point number two is, it's not that war should be announced, then national emergency can be imposed. External aggression should have taken place, then national emergency can be imposed. Armed rebellion has broke out, then national emergency can be invoked. No. President can proclaim national emergency even in anticipation of war, even in anticipation of external aggression, even in anticipation of armed rebellion. President is anticipating, based on the written advice of the cabinet, that there may be war, there may be external aggression, there may be armed rebellion. What the president can do? President can proclaim national emergency. That's point number one. Point number two. Today the president is proclaiming national emergency on the grounds of armed rebellion. Tomorrow he can change it and say this national emergency is imposed on the grounds of external aggression. Tomorrow he can say no, this national emergency is imposed on the grounds of war. That means president may always change the ground on the basis of which national emergency can be imposed in this country. These are two important things you need to keep in mind for your prelims examination. So what is national emergency? Under Article 352, if the president is satisfied because of the written advice of the cabinet that there is a danger to the security of the state, security of the nation as a whole, security of a particular state, security of any particular part of that state, because of war, external aggression or armed rebellion, president may proclaim national emergency to that effect. But now let's look at what is the validity of this presidential proclamation, which means for how long can national emergency continue in India? Here the president is proclaiming national emergency. This national emergency has to be approved by both houses of the Indian Parliament, Lok Sabha as well as Rajya Sabha, that too within 30 days, that too by special majority. That means now we know what these emergency provisions do to our constitution. These emergency provisions, 352, 356, 360, they disturb our federal constitutional credentials. They change our federal constitution into a unitary one. Despite the fact that we are not amending the constitution under Article 368, that's what these emergency provisions do. But how do they disturb this distribution of powers? How do they disturb this dual government? For that we need to understand what is 352, 356 and 360. Right now, let's focus on national emergency under Article 352. This national emergency, which has been imposed, proclaimed by the president, this will continue if within 30 days, both Lok Sabha as well as Rajya Sabha, they are approving this national emergency by passing a resolution by special majority. And what is the special majority? 2/3 of the members present and voting plus absolute majority. This majority is required for both Lok Sabha as well as Rajya Sabha so that they can approve this national emergency for 6 months. That means national emergency imposed today, it will continue for 30 days. Within this 30-day period, both Lok Sabha as well as Rajya Sabha, that too separately, they have to approve this national emergency by special majority. And if both Lok Sabha as well as Rajya Sabha pass a resolution by special majority, that means they are approving this national emergency. This national emergency can continue for 6 months. National emergency imposed continues for 1 month. Within 1 month, both Lok Sabha as well as Rajya Sabha, they have to approve this national emergency. And if they approve this national emergency, from the date the second house approves this national emergency, from that date, this national emergency continues for 6 months. After 6 months, what if we want to continue with this national emergency? We have to go back to the parliament. Please, Lok Sabha as well as Rajya Sabha. Just like you allowed us in the first instance, please approve this national emergency again. We want to continue with this national emergency. And this national emergency, if it is approved the second time by both houses of the Indian Parliament, that too by passing a resolution by special majority, this national emergency continues for another 6 months. And this 6 months is what we call periodic parliamentary control. And this periodic parliamentary control is very important for you to understand. What is this periodic parliamentary control? Number one, can there be an upper limit that national emergency can continue only for 6 months, or only for 1 year, or only for 2 years, or only for 3 years? There can be no upper limit. Why? Because we don't know for how long war will continue. We don't know for how long armed rebellion is continuing. We don't know for how long external aggression is continuing. That means we cannot fix the number of years. That means there can be no upper limit to the number of years national emergency can continue in this country. National emergency can continue in a state. National emergency can continue in any part of that state, because it is not necessary to impose national emergency on the entire nation. You can impose it on the entire nation, or you can impose it in a state which is affected, or any part of that state if it is affected, but there can be no upper limit because we don't know for how long this emergency situation is facing us. But each time, this is what we call periodic parliamentary control. If you want to continue national emergency, every 6 months you have to go back to Lok Sabha. Every 6 months you have to go back to Rajya Sabha. Every 6 months you have to go back to both houses of the Indian Parliament, seek their permission. If they pass a resolution by special majority, approve this national emergency, it will continue for 6 months. Then again for 6 months. Then again for 6 months. There can be no upper limit. But each time, both houses of the Indian Parliament have to approve this national emergency 6 months at a time. That is what we call periodic parliamentary control. That means we have to now understand what is the validity of this national emergency. National emergency imposed today within 30 days, both Lok Sabha as well as Rajya Sabha, they have to approve this national emergency by passing a resolution by special majority. If it is done, then this national emergency continues for 6 months. Can it continue beyond a period of 6 months? Yes, but take their permission again. Take the permission of Lok Sabha and Rajya Sabha again. Then continue for 6 months. Then again for 6 months. Then again for 6 months. And there is no upper limit. Which means, let's say for example, this is Lok Sabha, this is Rajya Sabha. National emergency is proclaimed today by the president. Within 30 days, Lok Sabha also passes a resolution by special majority. Rajya Sabha also passes a resolution by special majority. National emergency continues for 6 months. Clear? Now let's say for example, Lok Sabha approves it. Rajya Sabha does not approve it by special majority. National emergency stands revoked. Lok Sabha is not approving it, but Rajya Sabha has approved it. national emergency cannot continue, it is revoked. Now Lok Sabha is dissolved. Let's say for example today President proclaims national emergency. Within 30 days, both Lok Sabha as well as Rajya Sabha, they have to approve this national emergency. But within 30 days, Lok Sabha stands dissolved. Rajya Sabha has to give approval by special majority. And if Rajya Sabha gives approval by special majority, national emergency continues. But if tomorrow, for example, Lok Sabha is convened again, within 30 days, Lok Sabha has to approve this national emergency. That too by special majority. And if Lok Sabha does not approve this national emergency by special majority, despite the fact that this national emergency was approved by Rajya Sabha, this national emergency will not continue. That means national emergency imposed by the president based on the written advice of the cabinet continues for 6 months, provided both houses of the Indian Parliament they approve this national emergency by special majority. And both houses of the Indian Parliament they have to give approval to this national emergency after every period of 6 months. That is what we call periodic parliamentary control. But then, how can this national emergency be revoked? What are these options? Option number 1: President, on the basis of the written advice of the cabinet, imposes national emergency, proclaims national emergency. President, on the basis of the written advice of the cabinet, if the cabinet is recommending to the president, please revoke national emergency can be revoked. That means we know how national emergency is proclaimed. Now we are discussing how national emergency can be revoked. National emergency number 1 can be revoked at any point in time by the president, but not on his own, because president is an understand. President has to do everything on the basis of the advice of the Council of Ministers headed by the Prime Minister. So if the cabinet is giving a written advice to the president, please revoke national emergency, president will revoke national emergency. That's number 1. Number 2, if Lok Sabha passes a resolution approving national emergency, Rajya Sabha does not pass this resolution, national emergency stands revoked. Rajya Sabha passes this resolution to approve national emergency by special majority, Lok Sabha does not, national emergency stands revoked. But now a special power is given to Lok Sabha MPs under Article 352, Clause 8 of the Constitution. And what is this special provision to the members of Lok Sabha? 1/10 of the members of Lok Sabha. And please understand, the special power is not given to Rajya Sabha MPs. This is the exclusive power of the Lok Sabha. If 1/10 members of the Lok Sabha, they write to the speaker. But when can Lok Sabha MPs write to the speaker? Logic, common sense. If the Lok Sabha is in session, 1/10 of the members of the Lok Sabha, they write to the speaker. But if the Lok Sabha is not in session, 1/10 of the members of Lok Sabha, they write to the president. That dear president, please convene a special sitting of Lok Sabha. Why? Because we do not want to give approval to this national emergency. We want this national emergency to be revoked in this country. For that, within 14 days, president has to call the session of Lok Sabha. Within 14 days, speaker has to have a vote on national emergency in Lok Sabha. And it is in this session. If the resolution is passed by Lok Sabha, this time by simple majority. Remember this carefully. If 1/10 of the members of Lok Sabha, they write to the speaker. If the Lok Sabha is in session. If 1/10 of the members of Lok Sabha write to the president. If Lok Sabha is not in session, then what will happen? Within 14 days, there will be a voting on national emergency. And if in this session, Lok Sabha MPs they are passing a resolution, that too by simple majority, not by special majority. By simple majority, they pass a resolution. It is binding on the president to revoke national emergency. That means these are the ways of revoking national emergency. National emergency imposed by the president on the basis of the written advice of the cabinet. It continues for 6 months. Then again for 6 months. Then again for 6 months. There is no upper limit. But every 6 months, both Lok Sabha as well as Rajya Sabha, they have to approve this national emergency by passing a resolution by special majority. But then how can national emergency be revoked? It can be revoked at any point in time by the president, but only on the basis of the written advice of the cabinet. Second, if Lok Sabha approves national emergency, Rajya Sabha does not, national emergency is revoked. If Rajya Sabha approves national emergency, Lok Sabha does not, national emergency stands revoked. A special power is given to the MPs of Lok Sabha. If 1/10 of the MPs of Lok Sabha, they press for a special session of Lok Sabha by writing to the speaker or by writing to the president, then within 14 days, there will be the special sitting of Lok Sabha. And if Lok Sabha MPs pass a resolution by simple majority, president has no other option but to revoke this national emergency. This is what is national emergency, how it is imposed, on what grounds is it imposed, and how can this national emergency be revoked. But the bigger question is, what exactly happens because of national emergency? When we say national emergency is a provision which transforms our federal constitution into a unitary one. That's why we say our constitution is amphibian in character. Sometimes it behaves as if it's purely a federal constitution, but in abnormal circumstances, it transforms itself and becomes a unitary constitution. What exactly happens because of this national emergency? Effects of national emergency. And there are effects on multiple things because of this national emergency. Effect number 1 is on executive, the state executive. Effect number 2 is on state legislature. Effect number 3 is on the financial relations between center and the state. Effect is also on Lok Sabha. Effect is also on the state legislative assembly. Effect is also on fundamental rights enjoyed by the citizens of this country, enjoyed by the residents of India. For that, let's look at the effects of national emergency one by one. The first impact of national emergency is on center-state relations. In a federal polity, these are two major units, center and the state. Because of national emergency, number 1, there's an impact on this center-state relations. And the first impact on these center-state relations is on state executive. When we discussed center-state relations, then in administrative relations, I told you that center can issue directives to a state. And sometimes these directives are coercive. Coercive in the sense, these directives are binding on the states. These directives which are binding on the states, there are specific matters mentioned in the constitution. That in these matters, the directive issued by the center to the state is binding on the state. For example, means of communication, posts, telegraph, please maintain them. That's the directive issued by the center to the state, and it is binding on the state. Similarly, let's say for example, linguistic minorities from Maharashtra. there are people migrating to Karnataka. And these people who have migrated from Maharashtra to Karnataka, in Karnataka, they are linguistic minorities, Marathi speaking linguistic minorities. There is a directive that can be issued by the center to the state that these linguistic minorities, for their children, teach them at least in their primary stage of education in their own mother tongue. To make it even clear for you, for linguistic minorities, the center can issue a directive to a state, and this directive is binding on that state. What is this directive? There are Marathi speaking population migrating to Karnataka. Their children, they want to get access to education in Karnataka. A directive can be issued by the center to Karnataka state is that these linguistic minorities, their children, till their primary stage of education, till their fifth standard, they should be taught in their language, in their own mother tongue, which is Marathi. That means in Karnataka schools, these linguistic minority children should be taught in their own mother tongue, which is Marathi. And this directive is binding on the state. The states, they have to accept this directive. That means in normal circumstances, there are few matters. There are few matters where the directive issued by the center to the state is binding on the state. But when it comes to national emergency, any directive can be issued by the center to a state. And all these directives are coercive in nature. When we say all these directives are coercive in nature, if the state government is not accepting, is not abiding by these directives, dismiss that state government. Wow. What is happening here? The entire federal system is collapsing or transforming into a unitary one. What is the definition that I gave you of unitary constitution? In the first class, I told you South Africa is a unitary constitution. United Kingdom is a unitary constitution. But what happens in a unitary constitution? States or local governments, they exist at the mercy of the center. Center can at any point in time create these local institutions, create these states or abolish them as well. That means these states are because of the mercy of the center. At any point in time, the center can dismiss these states. That's exactly what can happen in a national emergency. That means in normal circumstances, directive issued by the center to a state is binding only on few matters. But in national emergency, the directive issued by the center to a state on any matter is binding. And if this directive is not followed by the center, and if this directive of the center is not followed by the state executive will be dismissed. That means the chief minister and her council of ministers dismissed. Center-state relations. First impact on executive. That doesn't mean that in a national emergency there are no state governments. State governments continue. They continue to function. There is council of ministers headed by the chief minister, but they are brought under the control of the center. Center can issue any directive to the state. State has to follow. And if the state does not follow these directives, dismiss that state government. Center takes over the entire control of that state. What is it? It's a unitary constitution. That means during national emergency, the state governments or the state executive is brought under the complete control of the center. So they are not suspended, but they are brought under the control of the center. When they do not follow the diktat of the center, they will be dismissed. They will be abolished. Impact number 1 on state executive. Impact number 2 on the state legislature. What is the impact of national emergency on state legislature? Distribution of powers. Union list, state list, concurrent list. Impact on state executive, which is dual government. That is one feature of a federal constitution is dual government. One government at the center, one government in every state as well. This dual government is under strain during national emergency. At any point in time, the center can dismiss the state government. The state government can brought under the complete control of the center. That means during national emergency, as I told you, our constitution changes its form and becomes unitary. When these state governments, they are brought under the complete control of the center. But then distribution of powers. Union list, defense, external affairs, communication, banking, insurance, all these matters. Who has the power to make laws? Central parliament. But there are matters mentioned in the state list. Law and order, land, police, agriculture, gambling. We say the state legislature has the power to make laws on any subject mentioned in the state list, but only during normal circumstances. Which are these abnormal circumstances? One such abnormal circumstance is a national emergency. That means during national emergency, state legislature is not suspended. State legislature continues. But parliament assumes the power to legislate on any matter mentioned in the state list. That means during national emergency, parliament assumes the concurrent power of legislating on any matter mentioned on the state list. Which means during national emergency, the normal distribution of legislative subjects between the center and the states is suspended, despite the fact that state legislature exists. State legislature is not suspended, but state legislature is brought under the control of the union parliament. Union parliament becomes empowered to make laws on any matter mentioned in the union list, mentioned in the state list, mentioned in the concurrent list. One more interesting point. Parliament assumes the power to legislate on any item mentioned in the state list. What if parliament is not in session? For that we have discussed that president can proclaim or promulgate an ordinance under Article 123 of the Constitution for a particular state also during national emergency. If the parliament is not in session, president can promulgate an ordinance on state subject if Parliament of India is not in session. That means ordinances can also be promulgated by the president on any matter mentioned in the state list when parliament is not in session. That means in legislative sphere also, it is the center which is dominant. That means our constitution, even without amendment, even without taking recourse to Article 368, becomes a unitary constitution. So now we have looked at that because of national emergency, there is an impact on state executive. State executive is brought under complete control of the center. Second, there is an impact on state legislature. That means parliament has now the power to legislate on any item mentioned on the state list as well, because national emergency is in place. And the third impact is on the financial matters. Let's say, for example, there is finance commission. After every 5 years, under Article 280 of the Constitution, the president has to convene or set up or establish a finance commission. One principal role of a finance commission is that this is divisible pool of taxes. Income tax, corporate tax, for example. Corporate tax, income tax is imposed by the center, collected by the center. But whatever has been collected by the center, this is to be shared with the states. These revenues are to be shared between the center and the states. During national emergency, this distribution of revenue can also be suspended. Look at what is happening because of national emergency. Even the distribution of revenue can be suspended during national emergency. That is another impact of national emergency on the financial matters now. But it is very important to understand here. Who can suspend this distribution of revenue between the center and the states during national emergency? This is something that is done by the president. The president cannot act on his own. It's basically on the advice of the Council of Ministers, headed by the Prime Minister. That means during national emergency, the President of India, a very important point, the President of India can suspend the distribution of revenue between the center and the state. That means the President will issue an order. Another important point is whenever such an order is issued, this order should be tabled on the floor of the Parliament. That means whenever President issues an order suspending this distribution of revenue between the center and the state, this order of the President has to be produced before the Parliament when it is issued. So the effect of national emergency is number 1 on state executive, number 2 on state legislature, number 3 on financial matters. In fact, there is an impact on the life of Lok Sabha as well as legislative assemblies. Now, please tell me one thing. There is war going on. Is it possible to conduct an election during war? Is it possible to conduct an election during external emergency or external aggression? Is it possible to conduct an election because there is armed rebellion going on? That means during national emergency, we have to ensure that the entire attention is on how can we win this war. Entire attention should be on how can we defeat this external aggression. The entire attention should be on how can we defeat this armed rebellion. How can we nip the evil in the bud? That means during national emergency, it may not be possible to hold an election as well. When it is not possible to hold an election, but the term of Lok Sabha is 5 years, the term of legislative assembly is 5 years, so there is no possibility of holding an election as well. During national emergency, the term of Lok Sabha as well as legislative assembly can be increased to 1 year or can be extended to 1 year. That means now the term of Lok Sabha is 6 years. Can it be extended further for another 1 year? Can it be extended further for another 1 year? How? Is there a limit to the number of years national emergency can be imposed in this country? Can continue in this country? There is no upper limit. Why? Because we don't know for how long war will continue. We don't know for how long external aggression will continue. We don't know for how long armed rebellion will continue in this country. So when we don't have an upper limit on the number of years national emergency can continue in this country, in a similar manner, we do not have the upper limit to the number of times we can extend the life, the duration of Lok Sabha and legislative assemblies. But you can extend it 1 year at a time. Which means if you want to continue with this national emergency, approve it for 6 months, then for another 6 months, then for another 6 months. That means both Lok Sabha as well as Rajya Sabha, they have to approve this national emergency for 6 months, then again for 6 months. But when it comes to the life of Lok Sabha and legislative assembly, you extend the life by 1 year at a time. 1 year is over, national emergency is still not revoked, it still continues, extend it by another 1 year. Extend it by another 1 year, but national emergency is still there. War is still going on, external aggression, armed rebellion still continuing. Extend the duration of Lok Sabha and legislative assemblies by another 1 year. That means please remember this carefully. During national emergency, Lok Sabha is not dissolved. Legislative assemblies are not dissolved. They continue. In fact, their life is extended 1 year at a time. But the biggest impact of national emergency is on fundamental rights. And there are two articles of the Constitution which define the effect on fundamental rights. One is Article 358 of the Constitution, and the other is Article 359 of the Constitution. Whenever national emergency is imposed on the grounds of war or external aggression, what happens? Fundamental rights under Article 19, they are automatically suspended because of Article 358 of the Constitution, which means now the impact of national emergency is more profound on fundamental rights. Whenever national emergency is imposed on the grounds of war or external aggression, or to make it even simpler, whenever external emergency is imposed in this country, then under Article 358 of the Constitution, fundamental rights under Article 19 are automatically suspended. And it is also fair because when there is war or external aggression, you can't ensure freedom of speech and expression. You can't ensure the fundamental right of every single individual to assemble peacefully without arms because there may be bombs dropping from the sky. So you have to ensure the security of the people as well. That means under Article 358, fundamental rights under Article 19 are automatically suspended. That means no separate order of their suspension is required. No separate order of suspending Article 19 is required whenever national emergency is imposed on the grounds of war or external aggression. But if the national emergency is imposed on the grounds of armed rebellion, then fundamental right under Article 19, they are not automatically suspended. Fundamental rights under Article 19 are not automatically suspended when national emergency is imposed on the grounds of armed rebellion. That means a separate order is to be issued. If at all, fundamental rights under Article 19 are to be suspended during the national emergency if it is imposed on the grounds of armed rebellion. If at all you want to suspend Article 19, for that the President has to issue a separate order. That means, to make it even simpler for you, long story short, there is an impact, a grave impact on fundamental rights because of national emergency. If the national emergency is imposed on the grounds of war or external aggression, Article 19 automatically is suspended. That means President need not issue a separate order to suspend Article 19. But if the national emergency is imposed on the grounds of armed rebellion, fundamental rights under Article 19 are not automatically suspended. Which means if the President, on the advice of the Cabinet, wants to suspend Article 19 during armed rebellion, a separate order for their suspension is required. But then what is Article 359? Article 358 deals with fundamental rights under Article 19. Article 59 says other fundamental rights may also be suspended by issuing an order under Article 359. But there are two fundamental rights which are not suspended. And which are these two fundamental rights? Article 20 and 21. To make it even simpler for you, under Article 358, when national emergency is imposed or when external emergency is imposed, Article 19 is automatically suspended. But should other fundamental rights also be suspended? Can be. For that, the President has to issue an order under Article 359, and President can issue order under Article 359 and suspend Article 14, suspend Article 15, Article 16, Article 17, Article 18, Article 22, Article 23, any fundamental right except Article 20 and 21. These two fundamental rights cannot be suspended under any circumstance. But now let me get into some technicality. It is not that under Article 359 that other fundamental rights are suspended. It's not that. It's not that under Article 359 fundamental rights can be suspended. It is only that their enforcement is suspended. That means you cannot approach to court. That means there is no judicial remedy available to you if your fundamental rights are violated during national emergency. That means under Article 359, other fundamental rights are not suspended. Only their enforcement is suspended. That means if during national emergency, Article 15, 16, 17, 18, 23, 25 are violated, there is no remedy available to you. You cannot approach the court. But there are two fundamental rights which cannot be suspended even during national emergency, and that is Article 20 and 21. That means under Article 359, if fundamental rights other than Article 20 and 21, they are theoretically alive, but their enforcement is suspended. That's what we have to keep in mind. Now comes the most important part of national emergency. To understand that, let me take you back. What are these emergency provisions? Article 352, 356, 360. These emergency provisions, what they do, even without formal amendment to the Constitution, they change our federal Constitution into a unitary one. And how? Number one, national emergency under Article 352. When this national emergency is imposed, how it can be imposed? What is the validity of this national emergency? How can it be revoked? But this national emergency has an impact on center-state relations, impact on state executive, impact on state legislature, impact on financial relations as well. And this national emergency has an impact on the life of Lok Sabha, the life of legislative assemblies as well. Their life is extended 1 year at a time without any upper limit. But the most serious is the impact of national emergency on fundamental rights. And fundamental rights under Article 19 are automatically suspended if the national emergency is imposed on the grounds of war or external aggression. But if emergency is imposed on the grounds of armed rebellion, Article 19 is not automatically suspended. It can be suspended if the President issues an order. But under Article 359, any other fundamental right can be suspended or their enforcement is suspended, but two articles, two fundamental rights are saved. Article 20, Article 21. But now, how many times has this national emergency been imposed in this country? The first time was in the year 1962 because of India-China war. Second time, 1971, because of India-Pakistan war, which led to the emergence of Bangladesh as an independent entity. And the third one was in 1975, when Indira Gandhi was the Prime Minister, and this emergency was the most notorious one. In fact, it was this emergency which is considered to be a dark spot, a black spot on India's democratic credentials. But what about 1965? There was an Indo-Pakistan war during 1965 as well. But the case here is, when emergency was imposed in 1962, this emergency continued till 1968. That means when 1965 war broke out, we were already in emergency. When we were already in emergency, that means no separate emergency order needed. That means when the emergency was imposed for the first time in 1962, it was revoked in 1968. That is why during the 1965 war, there was no need for a separate emergency because we were already under emergency. And then in 1971, emergency was imposed again. And in 1975, emergency was imposed again. And both these emergencies were revoked in 1977. But why was this 1975 emergency very notorious? It is argued that this was a black chapter, a black spot on India's democratic credentials. And this 1975 emergency was imposed on the grounds of internal disturbance. And it is argued that there are two big reasons why Indira Gandhi imposed this national emergency in 1975. The first is she lost a case in Allahabad High Court. Allahabad High Court said you are disqualified. Why you are disqualified? Because of electoral malpractice. This is something that we had discussed when we looked at Keshavananda Bharati judgment. So she was disqualified by Allahabad High Court. Then in Bihar, J. Prakash Narayan, he launched a movement, Total Revolution Movement or Sampurna Kranti. And it is because of this Allahabad High Court order and because of the JT movement that Indira Gandhi said there is internal disturbance. And this internal disturbance was used as a ground for the imposition of national emergency under Article 352 in the year 1975. And numerous human rights violations were committed during that emergency period. And you would know during this national emergency, a draconian law was also passed, NISA, Maintenance of Internal Security Act, under which student leaders, activists, trade union leaders, opposition leaders were arrested. And in fact, anyone arrested under NISA, he had no legal option as well. He was not provided any legal avenue to take back his liberty. Such was the draconian nature of this law, NISA, Maintenance of Internal Security Act. But when we discussed Keshavananda Bharati judgment of 1973, I told you that it is this judgment which saved India's democracy. For your mains examination, there is one similar question that can be asked. How did 44th Amendment to the Indian Constitution in the year 1978 prevented further misuse and abuse of Article 352 of the Constitution? 1977, when emergency was revoked, elections were called. Congress Party lost the election. Janata Party won the election. Morarji Desai became the Prime Minister of India. The Janata Party fought the election on one big ground, that we will undo all the changes made to the Constitution during this emergency period. Because if you recall, there is one amendment that we frequently talk about, 42nd Constitutional Amendment Act 1976. This is what we call a mini revision of Indian Constitution. And this mini revision of Indian Constitution, this amendment was done to the Constitution in the year 1976 when we were under emergency. So one big plank of election for the Janata Party was we will undo all these changes that have been made to the Indian Constitution during this emergency period. And they lived up to its expectation, to their expectation as well. When 44th Constitutional Amendment Act was passed in 1978. Keshavananda Bharati unfortunately died in 2020. Keshavananda Bharati, if this judgment saved India's democracy, it is this 44th Amendment to the Constitution of 1978 which prevented the future misuse of Article 352. And that is why from 1975 till 2020, no national emergency has been imposed. But you may be asked in your mains examination, what exactly was done in 44th Amendment which has prevented misuse of Article 352? Let's look at the characteristics, the provisions, the features of 44th Amendment which has prevented the misuse of Article 352. Feature number one, I told you that national emergency can be imposed by the President only on the written advice of the Cabinet. This written advice of the Cabinet was inserted because of 44th Amendment. 1975, when emergency was imposed in India, various reports say that Mrs. Indira Gandhi died, the President was in his bathtub taking a bath, and when Prime Minister called the President, based on the oral advice of the Prime Minister, the President proclaimed national emergency. Then the next morning, 6 o'clock, a Cabinet meeting was called. And when Cabinet meeting was called, Indira Gandhi presided over the Cabinet meeting and informed the Cabinet colleagues that emergency has been imposed. That means Prime Minister orally communicated to the President, please impose national emergency, and national emergency was imposed. That means Prime Minister did not consult her colleagues as well, did not consult her Cabinet colleagues as well. Cabinet colleagues were told the next morning when the Cabinet meeting was convened. Now, because of this 44th Amendment, what this amendment says that national emergency can be proclaimed by the President only on the written advice of the Cabinet. Previously, even an oral advice of the Prime Minister could have resulted in the proclamation of national emergency. Now it cannot happen. It has to be on the basis of the written advice of the Cabinet. That's change number one. Change number two, national emergency once imposed would have continued forever and ever and ever unless and until it is revoked by the President. That means national emergency once imposed prior to 1978, it could continue forever and ever and ever unless and until the President revokes it. Now, national emergency, if it is approved by both houses of the Indian Parliament, what is the majority required? The majority required is special majority. Prior to 1978 amendment, the majority required for approval was simple majority. That means if both houses of the Indian Parliament approve this national emergency by simple majority, national emergency could continue forever and ever and ever unless and until the President revokes it. Now this simple majority approval is changed to special majority approval. That's something that has happened because of 44th Amendment. Third thing that has happened prior to 1978 amendment, 44th Amendment, once this national emergency was imposed, it could have continued forever. Now it can continue only for 6 months. Then again for 6 months. Then again for 6 months. Then again for 6 months. And this periodic parliamentary control that we see, this periodic parliamentary control was also because of the 44th Amendment to the Constitution of 1978. Fourth thing, prior to 44th Amendment, any fundamental right would have been suspended by the President. Enforcement of any fundamental right would have been suspended by the President. But now because of this 44th Amendment, Article 20 and 21 cannot be suspended. That means two fundamental rights will never be suspended, even during national emergency, and that is Article 20 and 21. Fifth thing, prior to 44th Amendment, Article 19 was automatically suspended, but now Article 19 will not be automatically suspended if the emergency is imposed on the grounds of armed rebellion. This feature was added by 44th Amendment. Most importantly, internal disturbance, because prior to 44th Amendment, the President could have proclaimed national emergency on the grounds of war, external aggression, or internal disturbance. And this phrase was misused by Mrs. Gandhi when she got the president to impose national emergency in 1975. Now this phrase internal disturbance has been changed to armed rebellion, to overthrow the state. Unless and until ammunition is used, weapons are used to overthrow the state, no emergency can be imposed. Internal disturbance is very vague. People are protesting. People are protesting for their genuine legitimate demands. That is also internal disturbance. But people protesting for their genuine demands, for their legitimate rights, that cannot be deemed as a ground for national emergency. But the people are protesting, and through this process, they are taking up arms. And through these arms and ammunition, they want to overthrow the state. That is armed rebellion. That means unless and until there is armed rebellion, national emergency cannot be imposed. Seventh thing that has happened because of 44th Amendment, now a special power is given to the members of Lok Sabha. If 1/10 of the members of Lok Sabha they write to the speaker or the president, please call a special sitting. Within 14 days, a special sitting will be convened. And if by simple majority, Lok Sabha is passing a resolution disapproving national emergency stands revoked. All these features, they're basically safeguards to prevent the future misuse, overuse, or abuse of national emergency. And if Keshavananda Bharati judgment saved India's democracy, 44th Amendment of 1978 has prevented future misuse of Article 352 of the Indian Constitution. And that is because of all these important features. Because of these features, the misuse of Article 352 has been prevented. And in fact, the presidential proclamation that president proclaims national emergency, even this decision is subject to judicial review. That means, was president right in proclaiming national emergency, or do you think that the president's action was nullified? And it was in Minerva Mills' judgment of 1980 that Supreme Court said anybody can challenge the proclamation of national emergency on the ground that president's action was nullified, on the grounds that there was no reason to proclaim national emergency, on the basis of the ground that the facts on the basis of which president has proclaimed national emergency, these facts are absurd, these facts are immaterial, these facts do not deserve national emergency. That means one important thing is there will be judicial review whenever president proclaims national emergency under Article 352 of the Constitution, and that is what is national emergency. Now let's look at Article 356 of the Constitution that deals with President's rule. When Article 356 was being debated in the Constituent Assembly, Dr. B.R. Ambedkar said this article would remain a dead letter in our Constitution. That means although Article 356 is required, that is why we are incorporating it in our Constitution, but we won't be using it. So it is as if it will remain like a dead letter in our Constitution. But the provision of our Constitution which has been used, overused, misused, and abused, that is Article 356, which is President's rule. It has been imposed more than 110 times in different states in India. What is President's rule? What is the duration of President's rule? What is the misuse of President's rule? What exactly happens during President's rule? And we will also be discussing one of the most important and landmark verdicts in the history of independent India regarding President's rule, that is S.R. Bombay versus Union of India, 1994. So let's get started. First up, Article 355 of the Constitution. Article 355 imposes a duty on the center, on the Union, that it shall be your duty to protect the state, to protect every state from external aggression, to protect every state from internal disturbance. That's the constitutional duty on the center, on the Union, that you will have to protect a state from external aggression as well as from internal disturbance, as well as to ensure that the government of every state is being carried out according to the provisions of the Constitution. That every state respects the Constitution, follows the Constitution, and does not violate the Constitution at any cost. This is the duty of center or Union under Article 355 of the Constitution. And it is this duty that ensures that Article 356 can be used. What is Article 356? If the president is satisfied. But we know it is not the personal satisfaction of the president, it is the satisfaction of the cabinet headed by the prime minister. But Article 356 says if the president is satisfied. But what will satisfy the president? Governor's report or even otherwise. Now I'll tell you the meaning of this phrase, or even otherwise. If the president is satisfied on the basis of the report of the governor or even otherwise. What will be mentioned in this governor's report? This governor's report would mention that there is breakdown of constitutional machinery in a state. If the president is satisfied on the basis of the report of the governor or even otherwise, that there is breakdown of constitutional machinery in a state. The Article 355 imposes a duty on the center that you will have to ensure that the government of every state is being carried out according to the provisions of the Constitution. So if there is breakdown of constitutional machinery in a state, then what president will do? President will proclaim president's rule or impose president's rule in that state where there is breakdown of constitutional machinery. But when I told you, if the president is satisfied on the basis of the report of the governor or even otherwise, sometimes the governor's report also is not required. But president is satisfied that there is breakdown of constitutional machinery, then president's rule under Article 356 can be imposed in that state. For example, in the 1990s, in the early 1990s, M. Karunanidhi's government in Tamil Nadu was dismissed. President's rule was imposed in Tamil Nadu, even without a governor's report. That means although governor's report is important, but it is not a necessary condition for the imposition of president's rule. Even in absence of governor's report, president can impose a president's rule in a state if the president is satisfied that there is breakdown of constitutional machinery. But then how will president be satisfied? There may be intelligence report, there may be raw report, there can be any other report, not necessarily a governor's report, which will satisfy the president that there is breakdown of constitutional machinery, impose president's rule in that state. This is Article 356. That is how president's rule is imposed. Point number one, there is no definition of what is breakdown of constitutional machinery. Constitution does not define this phrase, breakdown of constitutional machinery. But park your thoughts, I'll explain slightly later what do we mean by breakdown of constitutional machinery. That means president's rule 1 can be imposed under Article 356 of the Constitution. Number 2, on the basis of Article 365 as well. What is Article 365? Something that we have discussed in center-state relations, in administrative relations between center and the state. Directives. Under Article 365, directives can be issued by the center to the state. What are these directives? Let's say, for example, CAA is to be implemented. West Bengal, Kerala, or any other state may say that we don't want to implement CAA. But CAA, Citizenship Amendment Act, is the law passed by the parliament. And the law passed by the parliament has to be respected in every state. If the center issues a directive to a state that please implement CAA and the state is not following this directive, is not abiding by this directive, that means the state is not following the directive issued by the center, it can be viewed that there is breakdown of constitutional machinery, and then Article 356 can be invoked, President's rule can be imposed in those states. Similarly, directives issued by the center to the states that there are means of communication of national importance, post and telegraph, railways, for example. You have to ensure that tribal schemes are executed. You have to ensure that tribal schemes are conceived, implemented in your states. You have to ensure that children belonging to linguistic minorities, they are taught at least till the primary stage of their education. They are taught in their own mother tongue. These directives are issued by the center to a state under Article 365. And the force of these directives under Article 365 is coercive in nature. That means if the state fails to abide by these directives, it can be viewed that there is breakdown of constitutional machinery, then president's rule under Article 356 can be imposed in that state. Long story short, if the president is satisfied, based on the report of the governor or even otherwise, that there is breakdown of constitutional machinery in a state, president's rule can be imposed in that state. Second, if directives are issued under Article 365, these directives are not abided by the states, these directives are not adhered to by the states, it can be viewed that there is breakdown of constitutional machinery, president's rule can be imposed in that state. And when the president's rule is imposed, presidential proclamation is issued. It's a very important term. President proclaims president's rule in a state under Article 356. But what is mentioned in this presidential proclamation? I'll tell you something very simply. But what is mentioned in this presidential proclamation? Let me take you towards that. Basically, governor's report. Governor submits a report to the president that there is breakdown of constitutional machinery. But president cannot act on his own. President is basically, sorry to use this phrase, a rubber stamp. President refers this matter to the cabinet. Let's say, for example, Home Minister, Cabinet, Prime Minister, they discuss and then they take a decision. Cabinet recommends to the president that we have received the governor's report and it is a fit case of president's rule. Cabinet advises the president, please impose president's rule. President proclaims president's rule in that state under Article 356 of the Constitution. But when the president proclaims president's rule, what exactly happens? This proclamation is very important. President by proclamation. What president can do? All executive powers of that state, he assumes all those powers to himself. That means normally governor plays a dual role. He is the executive head of the state. He is also a constitutional link between the center and the state. But when based on the governor's report, president's rule is imposed in that state, presidential proclamation says, number one, I am assuming all executive powers for myself. And these executive powers will be exercised through my governor. And it is in this case, when the state is under president's rule, the governor is the agent of the center. That means now governor is not bound by the aid and advice of the Council of Ministers because Council of Ministers dissolved. The first casualty in a president's rule is that the Council of Ministers headed by the Chief Minister that's dead, dismissed. And when there is no Council of Ministers, there is no Chief Minister, then who is the executive authority in that state? The executive authority, all these powers are now exercised by the president. That's what we call president's rule. That's why we call it president's rule. But president now exercises all these executive powers through his agent now. And this agent now is the governor. That's number one. So all executive powers of that state, now president assumes all these executive powers to himself. He exercises all these executive powers to his agent, who is the governor. But what about the legislature? Legislature is suspended. And that is what we call suspended animation. And I'll tell you slightly later what is this suspended animation. When the legislative assembly of that state is suspended, that means there is no legislative assembly. But for that state, laws are to be made. Laws are normally made by the legislative assembly. Now there is no legislative assembly. So who will make the laws? In this presidential proclamation, president may declare that now parliament will be the legislative assembly of that state. That means the legislature of that state would be the parliament. Later on, parliament may say, no, we don't want to exercise these powers. We will delegate these powers to you, Mr. President. That means we are delegating the legislative powers to you. You make laws for that state. To put it very simply, when president's rule is imposed in a state, there's something called presidential proclamation. President proclaims president's rule under Article 356 in a state. Let's say, for example, the state is Punjab. In this presidential proclamation, first thing that will be mentioned is who will take over the executive powers of Punjab. Executive powers will be taken up by the president, and president will exercise all these executive powers to his agent, who is the governor, because there is no chief minister. There is no council of ministers. The first casualty of a president's rule is the death of council of ministers headed by the chief minister. So executive function is sorted. The legislature. There is no legislature. Legislature is kept in suspended animation. So basically, legislature is suspended. When the legislative assembly is suspended, who will make laws for Punjab? President in his proclamation will say he will declare that the powers of the legislature shall be exercised by or under the authority of the parliament. If it is by the parliament, that means parliament will become the legislature of Punjab. Parliament will be making laws for Punjab. If it is under the authority of the parliament, then what parliament can do? Parliament will delegate these legislative powers to the president. That means during president's rule, you also make laws for Punjab. That's something else that can happen because of president's rule. And the third thing, president in his proclamation, very important point. He may make provisions for suspending, either in whole or part, in operation of any provisions of this constitution relating to any body or authority in that state. That means any provision of Indian constitution in its application to Punjab, which is placed under president's rule. For example, any provision of this constitution, either in its entirety or any part of this constitution, will be suspended by the president in this presidential proclamation. But the only thing that the president cannot do in this presidential proclamation, he cannot take over the powers of the High Court, or he cannot suspend the provisions of the constitution with respect to High Court of that state. Because separation of powers. There shall be separation of powers between executive and the judiciary. That means president of India cannot take over the judicial powers of that state, judicial powers of the High Court of that state, which is president proclaims president's rule, and he issues a presidential proclamation. In this presidential proclamation, what is mentioned? Number one, that the executive authority of that state, all these executive powers are now exercised by the president. That's what we call president's rule. And now president will exercise all these powers either through the governor or through other advisors that may be appointed by the president. That means president may also appoint advisors when it comes to president's rule in a state. Second, executive powers are taken. Now the legislative powers are either taken over by the Parliament of India or under the authority of the Parliament. These legislative powers are given to the president. You make laws for the state which is under president's rule. And one by one, any provision of Indian constitution, when it comes to its application to that state, which is placed under president's rule, this constitutional provision can be suspended except the provisions related to the High Court of that state. This is what happens in a president's rule. But we will come back to its effects slightly later. First, I tell you, president's rule is imposed by the president, and this president's rule shall have to be approved by both houses of the Indian Parliament, Rajya Sabha as well as Lok Sabha, within 2 months of its proclamation, that too by simple majority. But this president's rule, once it is proclaimed by the president, this president's rule shall have to be approved by both houses of the Indian Parliament within 2 months, that too by simple majority. That means more than half of the members present and voting. Let's say Lok Sabha approves it, Rajya Sabha does not approve it. President's rule will be revoked. Rajya Sabha approves it, Lok Sabha does not approve it. President's rule will be revoked. Let's say, for example, within 2 months, president's rule imposed today, within 2 months, Lok Sabha is dissolved. For a variety of reasons, Lok Sabha has been dissolved. If Rajya Sabha has approved president's rule, this president's rule will continue in that state. Continue. Now, Lok Sabha has been convened. Once new Lok Sabha has been convened, within 30 days of its convening, this Lok Sabha will have to approve President's rule within 30 days of its recommencement, that too by simple majority. Long story short, President's rule imposed today within 2 months. Both Lok Sabha as well as Rajya Sabha shall have to approve President's rule within 2 months, that too by simple majority. What if within these 2 months Lok Sabha is dissolved, but over a period of time it will be reconvened? A new Lok Sabha will be set up, a new Lok Sabha will be called in. When this new Lok Sabha is convened, within 30 days of its reconvening, this Lok Sabha shall have to approve President's rule by simple majority. That means within 30 days, provided if Rajya Sabha had approved it. If Rajya Sabha had not approved it in the past, that means President's rule cannot continue in that state. But once President's rule is imposed, how long will it continue? It will continue for a period of 6 months. Let's say within 2 months, both Lok Sabha as well as Rajya Sabha approve President's rule by simple majority. Once the other house has also approved, which means first if Lok Sabha approves it by simple majority, then Rajya Sabha approves it by simple majority. From the date Rajya Sabha, which is the second house, from the date the second house approves this President's rule by simple majority, from that date for 6 months, this President's rule will continue in that state. After that, can it continue further? Yes, for another 6 months. Provided again, both houses of the Indian Parliament approve President's rule by simple majority. Can President's rule continue beyond a period of 1 year? Yes, but only if 2 conditions are satisfied. Condition number 1, either national emergency has been imposed in the country or in that state or any part of that state. If that is the case, President's rule can continue beyond 1 year. And 2, Election Commission of India certifies that under the current situation, elections cannot be conducted. That means it is not suitable to conduct elections in these circumstances. If these 2 conditions are satisfied, then President's rule can continue beyond a period of 1 year. For how many years? 6 months, then again 6 months, then again 6 months, then again 6 months, which is total 2 years. 1 year here, 2 years here. That means the maximum constitutional validity for a President's rule is 3 years. Beyond 3 years, President's rule cannot continue because the maximum constitutional validity of a President's rule is 3 years. Let's recap and then we will jump to something very, very important. President's rule. Under Article 355, there is a constitutional duty on the center, on the union, that you will have to protect a state, every state, from external aggression, from internal disturbance as well. And the union, the center, has to ensure that the government of every state is being carried out according to the provisions of the Constitution. And that is how Article 356 kicks in. 356 says if the President is satisfied on the basis of the report of the governor or even otherwise, that there is breakdown of constitutional machinery in a state, what will happen? President's rule will be imposed by the President on that state. And when Article 356 is used, presidential proclamation is issued. That means President's rule is imposed in that state. In this presidential proclamation, what will be mentioned? President will say in his proclamation that all the executive powers of that state, I am assuming all these executive powers. And all these executive powers of the state will be exercised through government or through other advisors who I may appoint. So executive side is clear. In this presidential proclamation, the President may say that the legislature of that state, which is now suspended, the legislature of that state will be Parliament. That means who will make laws for that state? Either Parliament or under the authority of the Parliament. That means Parliament may authorize, may delegate the law-making power to the President. Please make laws for that state because this state is under President's rule. And the President, because of this proclamation, may suspend any provision of the Indian Constitution with respect to that state. Any provision of that Constitution with respect to that state except the provisions related to the High Court of that state. President's rule, once it is imposed, within 2 months, both houses of the Parliament shall approve this President's rule by simple majority. If approved, continues for 6 months. Can it continue beyond a period of 6 months? Yes, get the approval from Lok Sabha by simple majority, then it will continue for 6 more months. Can President's rule continue in a state beyond a period of 1 year? For that, 2 conditions must be satisfied. Condition number 1, either national emergency is imposed, either in the entire nation or in that state or any part of that state. And condition number 2, Election Commission of India certifies that under the current situation, because of the current scenario, it is difficult or not suitable to conduct elections, and in that case, President's rule will continue in that state for 2 more years. But every time, 6 months at a time. 6 months, 6 months, 6 months, 6 months, that means 2 years. Which means 2 years here, 1 year here, the maximum constitutional validity of a President's rule is 3 years. But what if President's rule has to continue beyond a period of 3 years in a particular state? For that, Constitution has to be amended. And that's what was done in case of Punjab. Because of the Khalistani uprising, because of internal disturbance in Punjab in the 1980s, because there was a movement for Khalistan, a separate independent country for the 6th Khalistan. That movement was there, and President's rule was imposed initially for a period of 3 years. Condition was still not ripe to conduct elections. Constitution was amended specifically for Punjab. That 3 years in case of Punjab means 4 years. Then it was extended beyond a period of 4 years as well, for 5 years. That means if President's rule, whose maximum validity under the Constitution is 3 years, if it has to continue in a state beyond a period of 3 years, for that Constitution has to be amended. And that is what was done in case of Punjab. 3 years is the maximum validity. In Punjab, it had to continue beyond a 3-year period. For that, Constitution was amended. Article 368 was used, and it was said that in case of Punjab, 3 years would mean 4 years. That means the maximum validity of President's rule for Punjab is 4 years, then 5 years. This means that if you want to exceed beyond a period of 3 years in imposing President's rule in a state, for that, Constitution has to be amended under Article 368 of the Constitution. This is how President's rule is imposed. President's rule, how can it be revoked? It can be revoked at any point in time. The President can revoke it on the basis of the advice of the Cabinet. This is where your Lakshmikant book is wrong. Lakshmikant book says President's rule can be revoked by the President on his own. That's a fairly incorrect statement. President cannot do anything on his own. President has to do everything and anything only on the advice of the Cabinet headed by the Prime Minister. So President's rule can be revoked by the President at any point in time on the basis of the advice of the Cabinet headed by the Prime Minister. But then what does Lakshmikant book mean when it says President's rule can be revoked by the President on his own? I tell you what must be going on in the minds of Mr. Lakshmikant when he wrote that book. When this phrase, President's rule can be revoked by the President on his own, it basically means that parliamentary approval is not required. Let's say, for example, national emergency. 1/10 of the members of Lok Sabha write to the Speaker of the President that we want a special sitting of Lok Sabha. We want to disapprove national emergency. Based on this resolution of Lok Sabha, President has to revoke national emergency. This kind of situation does not arise in case of a President's rule. That means President can revoke President's rule on his own, which means on the advice of the Cabinet, without any need of a parliamentary approval. That's what we call revocation of President's rule. At any point in time, it can be revoked by the President on the basis of the advice of the Cabinet headed by the Prime Minister. Or if Lok Sabha approves President's rule, Rajya Sabha does not, within 2 months, the President's rule is revoked. Rajya Sabha approves President's rule, Lok Sabha does not, which means the President's rule is revoked. These are the ways in which President's rule stands revoked in a state. Now, what exactly happens at a president's rule? The first casualty is the Council of Ministers headed by the Chief Minister dismissed. The Legislative Assembly normally is not dissolved, it is kept under suspended animation. That means it can be revived back, but as of now it is suspended, and now the job of the Legislative Assembly is taken over by Parliament, or Parliament may delegate the lawmaking powers to the President. Clear? But this Article 356 has been misused, overused, abused multiple times. For example, 1977 elections. Janata Party won the elections, and Janata Party immediately what it did, 9 Congress ruled states, their governments were dismissed. Why? Because the logic given by the then government was that we just had 1977 Lok Sabha elections. The Congress was routed. The Congress Party was defeated by the people. So if the people's support is lost, if the Congress Party has lost the support of the people, why should in 9 states Congress rule continue, Congress governments continue? And it was on this logic that the state governments in these 9 Congress ruled states were dismissed, President's rule was imposed. 3 years later, Indira Gandhi came back to power, and she did the same thing. What Janata Party did in 1977. The opposition ruled states, they were dismissed, President's rule was imposed. And there's a thin line in federalism between the union and the states, between the center and the states, which should not be crossed. Because if you cross it, you're basically violating federalism. Not just this, something else happened. 1992, Babri Masjid was demolished. The BJP governments in 3 states were dismissed. One government in Rajasthan, the other government in Himachal Pradesh, the third government in Madhya Pradesh. The logic given by the center was that there is breakdown of constitutional machinery because these 3 state governments, they have failed to curb the riots, and since there is breakdown of constitutional machinery, dismiss these 3 state governments in Madhya Pradesh, Rajasthan, Himachal Pradesh. But something unique happened in Karnataka. S.R. Bommai was the chief minister of Karnataka from 1988 to 1999 April. He was the chief minister, his party was Janata Party. There was another party, Lok Dal. Janata Party, Lok Dal merged, and they came to be known as Janata Dal Party. Long story short, close to 19 MLAs, they are writing letters to the governor that we have withdrawn support to S.R. Bommai government. To make it even simpler, there is Janata Party, there is Lok Dal. Both these parties merged. The name of the party is now Janata Dal. S.R. Bommai is the leader. S.R. Bommai is the chief minister from 1988 till April 1989. Okay? 19 MLAs now, they are allegedly writing letter to the governor saying that we have withdrawn support to S.R. Bommai government, which means now the S.R. Bommai government is a minority. S.R. Bommai government, since it is a minority, governor has made up his mind that I will dismiss him and I will submit a report to the president that there is breakdown of constitutional machinery, impose president's rule in Karnataka. But what is this breakdown of constitutional machinery? Constitution says there shall be chief minister, council of ministers in a state. If there is no chief minister, because the chief minister has lost the confidence in legislative assembly, that means there is breakdown of constitutional machinery. That means impose president's rule in Karnataka. The very next day, it came to light that at least 7 to 9 MLAs they are saying that we did not write this letter. So basically, the letter which was sent to the governor, when it was alleged that 19 MLAs they have withdrawn support to S.R. Bommai government, 7 to 9 of these MLAs they are claiming we did not write this letter. So basically, their signatures were forged. S.R. Bommai goes and meets the governor. Dear governor, I have the majority, but if you want, let's conduct a floor test. What is the floor test? I will prove my majority on the floor of the legislative assembly. Because can chief minister continue in his office? Yes, as long as she enjoys the majority on the floor of the legislative assembly. If you have the majority on the floor of the legislative assembly, you will continue. Otherwise, you have no other option but to resign. S.R. Bommai is asking the governor, dear governor, I think I have the majority. These letters which have been sent to you, MLAs are themselves claiming that we did not write this letter. At least 7 to 9 they're claiming we did not write this letter. Their signatures have been forged. So I know I have the majority. Give me an opportunity. Let's conduct a floor test. I will prove my majority on the floor of the legislative assembly. Governor is saying no. You have lost the majority. He submitted a report to the president that there is breakdown of constitutional machinery. President's rule was imposed. S.R. Bommai's government was dismissed. S.R. Bommai government was dismissed. S.R. Bommai approached the Supreme Court. And Supreme Court took a long time to pass this judgment, but nevertheless the judgment was passed. The year was 1993 and we call it 1994 S.R. Bommai judgment. And ultimately this judgment, although it came late, but this judgment has prevented the misuse, abuse of Article 356 of the Constitution. S.R. Bommai judgment, this judgment is one of the most landmark judgments in the history of independent India when it comes to the abuse of Article 356. When S.R. Bommai's government was dismissed, President's rule was imposed in Karnataka. S.R. Bommai approached Karnataka High Court that please hear my side of the story. I have been wrongly removed and dismissed as the chief minister. Karnataka High Court dismissed the petition of S.R. Bommai. S.R. Bommai approached Supreme Court naturally, Madhya Pradesh, Rajasthan, Himachal Pradesh. They also approached the Supreme Court that why would our government dismiss? Can the failure of ours in controlling our rights be viewed as breakdown of constitutional machinery? Please tell us. In Nagaland also the government was dismissed. They also approached the Supreme Court. We don't have to go too deep into what were these allegations and counter allegations. Long story short, multiple state governments were dismissed. Political parties approached the Supreme Court. Supreme Court said all these are raising one important issue: the misuse of Article 356. And it took many years for the Supreme Court to come out with a verdict, but nevertheless, Supreme Court, a constitution bench of the Supreme Court, came out with a verdict in 1993, 1994, S.R. Bommai versus Union of India. And this judgment, what Supreme Court said, Supreme Court laid down rules how and when President's rule can be imposed, and how can we prevent the misuse of Article 356 of the Constitution. The first thing that the Supreme Court said, that the government in Madhya Pradesh was dismissed. President's rule was imposed in Madhya Pradesh. Why? Because the government failed to control the riots. This is justified. And this is a fifth case of President's rule. Why? Because in Madhya Pradesh, since the government failed to control the riots, that means Hindu-Muslim riots, the state government failed to control, which basically means that secularism was violated. Secularism is part of the basic structure of Indian constitution. Since secularism was violated in Madhya Pradesh, that means there is breakdown of constitutional machinery. This is a fifth case of President's rule. Madhya Pradesh government was rightly dismissed by the central government. This is a fifth case of President's rule. Because if you violate secularism, which is part of the basic structure of Indian constitution, it can be viewed that there is breakdown of constitutional machinery. President's rule is justified. Supreme Court said that there is a difference between breakdown of law and order and the breakdown of constitutional machinery. For example, I'm a political party. I am in my election manifesto saying that I will give you these many freebies. I will open a university, I will open a college, I will open a dispensary, I will give you juice mixer grinder, I will give you a gold coin, I will give you a buffalo. These are the promises made by various political parties in their manifesto. If tomorrow I come to power and I fail to give shape to my election manifesto, which means if I do not abide by my election manifesto and then there are people protesting against my government, and if there are people protesting, it is breakdown of law and order. It is not breakdown of constitutional machinery. Breakdown of constitutional machinery is what happened in Madhya Pradesh. There were riots, communal riots, unfortunately on the basis of the religion. Since secularism was violated, this is the fifth case of President's rule. That means there is a distinction. A distinction was made by the Supreme Court between breakdown of constitutional machinery and the breakdown of law and order. If there is breakdown of law and order, for that call it paramilitary forces. For that call it army also maybe. But you cannot be imposing President's rule on the basis of the failure of law and order, on the basis of the breakdown of law and order. You can impose President's rule only if there is breakdown of constitutional machinery. That's number 2. Number 3. Supreme Court said judicial review. Judicial review is part of the basic structure of Indian constitution. Whenever the central government imposes President's rule in a state, anybody can approach us and we will conduct a review of this President's rule. This is where it becomes even more interesting. How is President's rule imposed? Governor submits a report to the President. President gives the report to the cabinet. Cabinet discusses this, and cabinet then advises the president that please impose President's rule in the state. And here, if there is judicial review, that means basically you are trying to get into the advice tendered by the Council of Ministers to the president. What is judicial review? We will review on the basis of what did you impose President's rule. But where is it mentioned? In the advice tendered by Council of Ministers, the cabinet to the president that please impose President's rule. But there is a constitutional bar under Article 74 Clause 2. What is this constitutional bar? That the advice tendered by the Council of Ministers to the president cannot be inquired into in any court of law. That means judiciary cannot get into the advice tendered by the Council of Ministers to the president. Confusing? Let me make it simpler. President's rule. How is it imposed? It is imposed when the cabinet advises the president, please impose President's rule. So President's rule is imposed by the president, basically on the advice of the cabinet. But this advice of the cabinet cannot be inquired into in any court of law. That means court cannot ask the president, show me this advice. the Prime Minister, tell me what is this advice that you have given the President? Because there is Article 74, Clause 2. So if the Supreme Court in SR Bommai judgment is saying that there will be judicial review, how will there be judicial review when the advice tendered by the Council of Ministers to the President cannot be inquired into any court of law? Government lawyer told this to the Supreme Court. How can you do this? And how can you conduct a judicial review when there is Article 74, Clause 2, which says the advice tendered by the Council of Ministers to the President cannot be inquired into in any court of law? Supreme Court pondered, thought, and said, perfectly fine. Yes, we cannot get into the advice tendered by the Council of Ministers to the President. So what we will do? We will still conduct a judicial review. We will still hold a judicial review. We will not get into the advice tendered by the Council of Ministers to the President, but we will go into the material on the basis of which this advice was given. So what? The advice tendered by Council of Ministers cannot be inquired into in any court of law. Clear? And it is based on this advice that President's rule is imposed in the state. So if there is judicial review, that means basically you have to go into this advice. Where exactly did Cabinet advise the President to impose President's rule? Since there is Article 74, Clause 2, which means the judiciary cannot get into this advice, then how will judiciary conduct judicial review? The court said no. We will not get into the advice, specific advice tendered by Council of Ministers to the President. We will get into the material on the basis of which the advice was given. So this advice was given based on Governor's report. We will get into the Governor's report. This advice was given maybe on the basis of intelligence report. We will get into the basis of this intelligence report. And we will check whether this material justifies President's rule or not. It is for the center to ensure and establish that there exists a material on the basis of which advice was given to the President to impose President's rule. We will not get into the advice, but we will get into the material. We will get into the material on the basis of which this advice was given to the President. That means judicial review is possible. The Supreme Court was told something else. Supreme Court was told, their Supreme Court, you know what happens? Legislative Assembly, as soon as President's rule is imposed, it is dissolved. Normally, it is dissolved. I told you normally it is not dissolved. It is kept under suspended animation. But that is the position now. Prior to SR Bommai judgment, as soon as President's rule was imposed, sometimes, as soon as President's rule was imposed, Legislative Assembly was dissolved. When Legislative Assembly was dissolved, there is no other option but to conduct an election. This was communicated to the Supreme Court. That what if you conduct a judicial review, but by the time you give the verdict, Legislative Assembly is dissolved. Now, what is the logic and the objective of your judicial review? Supreme Court said, number one, you cannot dissolve Legislative Assembly unless and until both Lok Sabha as well as Rajya Sabha, they have approved President's rule. So without the approval of both houses of the Parliament, don't dissolve the Legislative Assembly. And even if you do, we have the power to revive back the dissolved Legislative Assembly. We will give life back to that dissolved Legislative Assembly and we will revive it back to power. That's what Supreme Court said in SR Bommai versus Union of India. In this SR Bommai judgment of 1994, Supreme Court also listed some proper and improper situations where President's rule can be imposed. One proper situation where the President's rule is imposed, take the example of Maharashtra. In 2019, election was conducted, single largest party was BJP, then Shiv Sena, then NCP, then the Congress. Although BJP and the Shiv Sena were in a pre-poll alliance, but Shiv Sena said no, make us the chief minister, otherwise we will not join the government. Ultimately, the governor asked the head of the BJP in Maharashtra, Devendra Fadnavis, can you form the government? Mr. Fadnavis said, I don't have the numbers. The governor asked Uddhav Thackeray of the Shiv Sena, can you form the government? Uddhav Thackeray said, we don't have the numbers. The governor then asked Sharad Pawar, NCP, can you form the government? Which basically means after the election, there was hung assembly. Hung assembly, no political party on its own forming the government, and no other political party coming together to form the government, which means there is breakdown of constitutional machinery. This is the fit case of President's rule. After the election, no political party has backed the majority. No political party is in a position to form a coalition with another political party, which means there is breakdown of constitutional machinery. This is a fit case of President's rule. Second fit case, BJP and PDP in Jammu and Kashmir, they were in power. Suddenly in 2018, the BJP decided to withdraw support to Mehbooba Mufti government. No other combination was possible. That means the government has fallen, primarily because of the fact that one coalition partner has withdrawn support and no other political party is in a position to form the government. This is the fit case of President's rule. Third fit case, directives are issued by the center to the state. Let's say, for example, West Bengal government, please implement CAA. Why are you saying that we will not implement CAA? Directive is issued by the center to the state that please implement CAA. And if this directive is not abided by the state, it's a fit case of President's rule, impose President's rule in that state. Another fit case, internal subversion. What is internal subversion? The government itself is violating the constitution. The government itself of a state is violating the laws. The government is instigating people to commit riots. That can also happen. Instigating people against the center. This is breakdown of constitutional machinery, impose President's rule. But what are these improper situations? Number one, SR Bommai judgment. SR Bommai was dismissed as the chief minister. You decided to impose President's rule without giving SR Bommai the opportunity to go for floor test. That means governor is nobody to assume that the chief minister does not have the majority. The governor is nobody to assume that the chief minister does not enjoy majority. Whether the chief minister has the majority or not, that can be decided only on the floor of the Legislative Assembly. That means floor test. If the floor test is lost by the chief minister, then you can impose President's rule. But even then, you have to explore alternatives. You have to explore that other political parties are coming together to form the government. That means what the governor did in case of SR Bommai, he assumed that the chief minister does not have the majority. Despite the fact the chief minister said, I'm willing to hold and go through the floor test. This is improper use of President's rule. Don't do that. Second, Supreme Court said, even if a state is not abiding by the directives of the center, give that state warning. First should be warning. And even after warning, if the state is not abiding by your directives, then impose President's rule. Without warning, if you are imposing President's rule, that is improper. Third, Supreme Court in one way was referring to what happened in 1977 and 1980. 1977, Janata Party came to power. Janata Party saw that there are 9 state governments ruled by Congress. But Congress Party was defeated in the elections. That means Congress Party does not enjoy support in the eyes of the people. Dismiss these 9 Congress ruled states or these governments. That is improper. Just because a political party lost a general election, that doesn't mean this political party, if it is governing various states, these state governments are to be dismissed. Improper use of President's rule. Fourth, allegations of corruption. If there are corruption allegations against chief ministers, and because of that you are saying there is breakdown of constitutional machinery, no. This may be breakdown of law and order. But this is not breakdown of constitutional machinery. That means by issuing this list of proper and improper usage of President's rule, the Supreme Court relied on the Sarkaria Commission report. Sarkaria Commission was set up on center-state relations. It submitted its report in 1987, but these recommendations still have not been accepted in their entirety. And Supreme Court relied on the Sarkaria Commission report about the proper usage and improper usage of President's rule. Supreme Court further said that there is a delicate balance in our federal setup, and this balance should not be violated. Otherwise, our federal constitution will turn itself into a unitary constitution. That means SR Bommai judgment has prevented the misuse and abuse of Article 356 of the Constitution. And this is best explained by the fact that when President's rule was imposed in Uttarakhand, when Harish Rawat's government was dismissed, President's rule was imposed. Uttarakhand High Court quashed this President's rule, said this President's rule was improperly used by the centre. The year was 2016. In a similar fashion, President's rule was imposed in Arunachal Pradesh. And Supreme Court of India in 2016 said that this imposition of President's rule in Arunachal Pradesh is in gross violation of SR Bombay judgment. That means SR Bombay judgment has prevented the misuse of Article 356, just like Keshwanda Bharti judgment has preserved and saved India's democracy, just like 44th Constitutional Amendment Act has prevented the misuse of Article 352. Lastly, regarding this President's rule, and for that we will go back to Maharashtra. Maharashtra, curious case. In 2019, the President's rule towards the end of 2019 was revoked by the President. How? President's rule is imposed by the President, and I told you on the advice of the Cabinet, headed by the Prime Minister. Can the President's rule be revoked by the President? Yes, on the basis of the advice of the Cabinet. But something happened in Maharashtra. Four parties, BJP, Shiv Sena, NCP, Congress, fought the election. No political party got the majority. Although BJP and Shiv Sena, they contested the election together as alliance partners. But nevertheless, after the election results were announced, Shiv Sena bargained hard. Shiv Sena wanted chief ministerial post. BJP was adamant that we will not give you. Ultimately, no government was possible, and that's the fifth case. Proper use of Article 356. President's rule was imposed. One fine evening, news channels are flashing. Uddhav Thackeray all set to become the chief minister of Maharashtra. It has been decided that Congress, NCP, and Shiv Sena will come together to form the government, and Uddhav Thackeray will become the chief minister. I slept, and next morning I got up. I saw Mr. Devendra Fadnavis has been sworn in of BJP as the chief minister, and Ajit Pawar of NCP is now the deputy chief minister. But the state was the President's rule. 5:47 a.m. in the morning, the President is revoking President's rule, even without Cabinet recommending it. Cabinet did not recommend revocation of President's rule, but the President revoked President's rule 5:47 a.m. in the morning. How is that possible? That is possible because of rule number 12 of the Transaction of Business Rules 1961. All the executive powers are vested in the President. President can issue orders how these executive powers have to be exercised. For that we have these rules. Transaction of Business Rules 1961. Transaction of Business Rule 1961, rule number 12. It talks about departure from rules. Transaction of Business Rules, these rules are to be followed. Rule number 12 of these rules say departure from rules. That means at some time you can also depart from following these rules. And what rule 12 says? Prime Minister, even without Cabinet meeting, can use an extraordinary power and recommend something to the President. Prime Minister, maybe at the dead of the night, because there was no time to convene the Cabinet meeting, it could not be convened at the dead of the night. And in the dead of the night, Prime Minister is using an extraordinary power, rule 12 of Transaction of Business Rules 1961, recommending to the President, please revoke President's rule. That means even in Maharashtra, the President did not revoke President's rule on his own. He revoked on the advice of the Prime Minister. But normally the advice of the Cabinet is required. But there is an extraordinary rule. Rule 12 departed from rules. In extraordinary circumstances, even without a Cabinet meeting, Prime Minister may call for the revocation of the President's rule, may advise for the revocation of the President's rule, and that is how it was done. And 5:47 a.m. in the morning, President's rule was revoked based on the order issued under Rule 12 of 1961, and that was done by the President on the basis of the advice of the Prime Minister without consulting the Cabinet. This is about President's rule. So we have discussed emergency provisions 1, Article 352, 2, Article 356 of the Constitution. Now let us discuss financial emergency under Article 360 of the Constitution. Please understand this thing. National emergency under Article 352 has been proclaimed twice. First in 1962, then in 1971, and then in 1975. President's rule under Article 356 has been proclaimed a number of times, more than 110 times in India. But financial emergency under Article 360 of the Constitution has never been proclaimed in India, and we can only hope that it is never proclaimed in India. But what is financial emergency? Constitution says under Article 360, if the President is satisfied. Now what can satisfy the President? Basically the advice of the Council of Ministers, the Cabinet, headed by the Prime Minister and the Cabinet advises the President, please proclaim financial emergency, and financial emergency under Article 360 will be proclaimed by the President. But the Constitution says if the President is satisfied. Now what will satisfy the President? That the financial condition or the financial stability or the credit of the nation is under threat. Then what the President will do? He will proclaim financial emergency under Article 360 of the Constitution. But what do we mean by financial stability or credit of the nation or the union is under threat, and then President will proclaim financial emergency? We may not know. Why? Because as I told you, financial emergency has never been proclaimed in India. If you recall 1991 economic crisis, which is what we call BOP crisis as well, balance of payment crisis, which we will discuss in detail in economics lectures. At the time of BOP crisis or the financial crisis of 1991, it is argued that we have forex reserves which would last only for 3 weeks of imports. That means we have to import. For that, we will have to pay using our foreign exchange. This foreign exchange would last only for 3 weeks and then it will be exhausted. That means the financial stability and credit of the nation was under grave threat in the year 1991. Some newspaper reports say that the forex reserves would last only for a few days. Some reports say for 3 weeks. Some reports say for a few days. But even at that time, at the peak of this financial crisis, financial emergency was not imposed. Then again, in the year 2008, 2009, because of the global financial crisis, which again you will discuss in detail in your economics lectures, even at that time, in 2008, 2009, financial emergency was not imposed. And then again during 2019 COVID crisis, when on 31st of August 2020, the GDP figures were known. The GDP, the real GDP figure, it shrank minus 23.9% from the year ago. That means even at the time of COVID-19 crisis, when economic indicators plunged, even then financial emergency was not imposed in India. So we may never know what exactly do we mean by this phrase when the president is satisfied, when the financial stability or credit of India or any part of India is under threat or threatened, then financial emergency can be proclaimed by the president. We may never know because it was not imposed in 1991, not imposed in 2008, 2009, not imposed during the COVID-19 pandemic as well. But what we know for sure is that if the president is satisfied, when the financial stability or credit of the nation or any part of the territory of India is threatened, then what president can do? He can proclaim financial emergency. And it is needless to say that president proclaims financial emergency only on the advice of the Council of Ministers headed by the Prime Minister, which is basically on the advice of the cabinet headed by the Prime Minister. But now let's look at the duration of financial emergency, how it can be imposed and how it can be revoked. If the president is satisfied, then what the president will do? President will proclaim financial emergency. This financial emergency has to be approved by both houses of the parliament, that means both by Lok Sabha as well as Rajya Sabha, within 2 months, and that too by simple majority. That means president proclaims financial emergency. Once it is proclaimed, within 2 months of its proclamation, this financial emergency needs to be approved by both houses of the Indian Parliament by passing a resolution by simple majority. And once both Lok Sabha as well as Rajya Sabha, within 2 months, approve this financial emergency by passing a resolution by simple majority, then this financial emergency continues till the time it is revoked by the president. That means there is no upper limit. Financial emergency once imposed can continue forever and ever unless and until it is revoked by the president. That means like national emergency, it need not be approved by parliament every 6 months. That means like president's rule, there is no upper limit because president's rule has an upper limit of 3 years beyond which president's rule cannot continue as state. Financial emergency once imposed by the president on the advice of the Prime Minister and the cabinet can continue forever and ever unless and until it is revoked by the president. That means there is no upper limit on the number of years or the duration during which this financial emergency can continue. So this topic financial emergency is relevant only for your children's examination because it has never been imposed in this country, which means there are no cases of its misuse. So it is less and less relevant for mains, but mostly relevant for your children's examination. So you should know the facts about this. But what might happen or what can happen when financial emergency is imposed by the president? Number one, Constitution says during the period of any such proclamation, when financial emergency is imposed, the executive authority of the union shall extend to the giving of directions to any state. That means during this financial emergency, the central government will issue directives to a state or to all the states. What are these directives telling these states? Please observe canons of financial propriety. But what do we mean by canons of financial propriety? What do we mean by this phrase? Let's say, for example, 2009. When the 2009 global financial crisis was going on, at that time, the finance minister was Pranab Mukherjee. Pranab Mukherjee, who later on became the president of India, unfortunately passed away in the year 2020. He was also suffering from COVID-19 as well. Pranab Mukherjee was the finance minister, and as finance minister, he asked all the cabinet colleagues, please maintain canons of financial propriety. That means don't stay in 5-star hotels, use government accommodation, don't fly business class, fly economy class. As much as possible, limit your expenditure because we are in a financial crisis. But even during that time, as I told you, financial emergency was not imposed. But we may get to know what do we mean by this canons of financial propriety. Don't travel business class, which means during financial emergency, the directives can be issued by the center to the states. Please observe canons of financial propriety. Other directives can also be issued. Which are these directives? Number one, there are government employees, engineers, doctors, teachers, technicians, others. Their salaries may be reduced during financial emergency. That means the center will issue directives to the state that please reduce the salary of your employees. That can happen. Second thing that can happen is that money bills or financial bills under Article 207 of the Constitution. With respect to the states, there is a financial bill under Article 207. Directive can be issued by the center to the states that once your state legislative assembly passes a money bill or a financial bill, please reserve this for the consideration of the president. That means before governor gives his assent to these money bills and financial bills, these bills must be reserved for the consideration of the president. That is another directive that can be issued by the center to the states during financial emergency. And in fact, during financial emergency, all the employees at the union level as well, their salaries can also be reduced, including, and this is very important for your films, including the salaries of the judges of the Supreme Court and High Courts. That means what is financial emergency? Number one, if the president is satisfied, and what will satisfy the president? That there is a threat to the financial stability or the credit of the nation or any state or any territory in India, then what president can do? He can proclaim financial emergency. Once this financial emergency is proclaimed, both houses of the parliament, they have to approve this financial emergency within 2 months of its proclamation. That too by passing a resolution by simple majority. That means majority of the members present and voting. And once it is approved by both houses of the Indian Parliament by simple majority, financial emergency continues unless and until it is revoked by the president. That too on the advice of the cabinet headed by the Prime Minister. That means there is no upper limit to the number of years or the duration. There is no limit to the duration of financial emergency. But if Lok Sabha approves financial emergency, Rajya Sabha does not, financial emergency will be revoked. If Rajya Sabha approves financial emergency, Lok Sabha does not, financial emergency will be revoked. Once both houses of the Indian Parliament approve by simple majority this financial emergency, that too within 2 months of its proclamation, financial emergency continues unless and until it is revoked by the president. But what happens during financial emergency, we don't know. Number one, it has never been imposed in this country. Number two, neither in 1991, not in 2008, 2009, not during COVID-19, financial emergency was not imposed. But what might happen during financial emergency? Constitution talks about it. Constitution says, observe canons of financial propriety. This directive can be issued by the union to the states. That's number one. Number two, salaries of state government employees can be reduced. Number three, what can happen is that all these bills, money bills, dealing with money, financial bills, dealing with money, these bills once approved by the state legislatures, they may be reserved for the consideration of the president. And at the union level, the salaries of government employees at the union level may also be reduced, including the judges of the Supreme Court and the High Courts. This is what can happen during financial emergency. You need to understand something else, and this is a question that students normally ask us. Let's say, for example, during COVID-19, ministers, members of the parliament, they decided to take salary cut. Chief election commissioner, election commissioners, they also decided to take salary cut. How is it justified? Or is it not financial emergency? Because they have decided to reduce their salaries, to reduce their take-home salary. But the point is, they're doing it voluntarily. Constitution says the salaries of CAG, salary of judges of the Supreme Court, High Court, they cannot be varied to their disadvantage after their appointment. That means once I'm appointed, my salary is X. After my appointment, it cannot become X minus 2 because you're varying my salary to my disadvantage. This cannot happen. This can only happen during financial emergency. Similarly, the salaries of chief election commissioner, election commissioners, they can be varied to their disadvantage only during financial emergency. Which means, long story short, the salaries of government employees at the union level, at the state level, can be reduced to their disadvantage, but only during financial emergency. And this is something that you need to know regarding financial emergency, Article 360 of the Constitution of India.